Good afternoon, everyone. This is Hyoung SHIN, the Vice President of Korea Polar Research Institute, the lead agency of the National Polar Research Program, and ex officio the chief scientist of the Institute. I feel ecstatic about today's workshop. First of all, I and Professor Akiho SHIBATA would like to wish everyone a happy Antarctica Day. The Antarctic Treaty was signed on December 1st, 2059. So today is the 64th birthday of the treaty, if you will. What an appropriate day it is to have this workshop on the future of Antarctic governance with particular focus on the Antarctic environmental liability and lawyers' role in consensus building. The Antarctic Treaty is a disarmament concordat, an environmental convention, and science agreement at the same time. It is a mature, yet evolving international instrument about a special and unique place, the Antarctica, a testbed of science-based policy makings and peaceful collaboration toward joint environmental stewardship. Next year's ATCM will take place in Kochi, India, and then followed by Italy in 2025, Japan in 2026, and Korea in 2027. Recalling China hosted an ATCM in 2017, we are seeing 4 ATCMs hosted by Asian countries in just about 10 years. In that sense, this workshop, organized by PCRC, Polar Cooperative Research Center, Kobe University, and Korea Polar Research Institute, KOPRI, is a meaningful occasion, well poised to examine the contemporary issues centered around the Antarctic Treaty and its Madrid Protocol, particularly from Asian perspectives. The Antarctic governance, guided by the Antarctic Treaty and its environmental protocol, is faced with a number of challenges, many of which involve intricate legal issues. One of them is the entry into force of Annex 6 on environmental liability. That was adopted back in 2005 and is yet to be approved by all parties. Entry into force of these measures can be a demonstration of commitment and perhaps a measure of success as well. Lawyers and experts from 4 Asian consultative parties and other parties have gathered in Kobe today in order to discuss how they might assist in addressing these challenges and upholding and strengthening the Antarctic governance under the rule of law, the Antarctic Treaty. Kobe University PCRC and KOPRI, in collaboration with other partner institutions, plan to organize a series of workshops and seminars in a design and structure way up until at least 2027. Our hope is to have the next one in conjunction with the Kochi ATCM that was just mentioned, with the cooperation of the Indian institutions and the host government. Now, I'm almost done. Here are some housekeeping and rules for today's discussion. In this workshop, all invited speakers, in person and online attendees are participating as experts and in their personal capacity, unless otherwise indicated explicitly by themselves. The entire workshop, including the discussions, will be video recorded, and the co-organizers will make these videos publicly available through YouTube. All registered audience, both on-site and online, will receive a notification when the videos are ready for on-demand viewing. At the moment, we have about 60 people online audience from 21 countries and about 30 persons as on-site audience in this room. Many of them are master course students at Kobe University Graduate School of International Cooperation Studies. Thank you for your participation. The online audience can write commentaries and questions using the Zoom webinar Q&A functions. Due to time constraints, however, the co-chairs are not likely able to take them up during the workshop. All entries of comments and questions, however, will be considered later by the co-organizers for future reference. Thank you for your understanding on this matter. Now, we will set the stage, and no separate introduction will be made on the individual speakers, as they are already available on the program, web posted and distributed in paper in this room. Professor Akiho SHIBATA from Kobe University and Ville KARI from Tilburg University will make a 20-minute presentation each to set up the stage for the key issues to be discussed during the workshop today. Thank you very much. Akiho, please.
Okay, welcome again. My name is Akiho SHIBATA, Professor of International Law and Director, Polar Cooperation Research Center. And as the co-host of this workshop, I welcome you all, both in person and online. But I have an additional role here to set the stage for the discussions and presentations that will follow us. So Ville KARI and I will present an overview of the issues that we are facing today. All right, so how should I do it? Can I do it like this? Maybe not. Okay, that's all right. Thank you very much. So I'm a professor of international law. So my presentation is academic analysis of the Annex 6. However, I do have some practical experiences, both on the ground in the Antarctica. I've been to Antarctica from 2016 to 2017, and also I've been participating in the Antarctic Treaty Consultative meetings, the ATCM. And as you can see, Chul and I was in Helsinki participating together, and you probably see some familiar faces from that photo. So I try to be practical when I make my academic analysis of the Annex 6. All right, so Annex 6 is on Antarctic environmental liability. It was adopted, as Chul has mentioned, in 2005, but it is the major lawmaking exercise under the ATCM after the Madrid Protocol was adopted in 1991. Environmental liability generally is a very, very intricate legal system, and extremely complex negotiation always follows. And also, it poses difficulties in domestic implementation. We know that from the very beginning of the negotiation and also after the adoption. Particularly, the liability under the Antarctic Treaty, it has been a long and complex negotiation. It has already started when another treaty called KRAMLA, which is Convention on Regulation of Antarctic Mineral Resources. So there was several provisions on the liability even in that treaty already in 1988. But it was not a complex liability regime. That treaty, KRAMLA, has been in a way abandoned, and became the new treaty, which is the Madrid Protocol adopted in 1991. And in the Madrid Protocol, there is Article 16, specifically on this environmental liability issue. And then following that, we have this Annex 6 negotiation started already in 1992 and coming to the success in 2005. So you can see how much of the effort that the consultative parties put them together into those negotiations over almost 2 decades on it. So it is an unprecedented liability regime for public spaces. And so this is from my article in 2009. And it is, according to my view, is a miracle, almost a miracle in obtaining the consensus of all, at the time, 28 consultative parties in 2005. At the same time, Antarctica is already the best protected area of the Earth under the Madrid Protocol, but its uniqueness and fragility required special liability regime focused more on prevention and emergency situations. Environmental emergencies are still rare cases. Ville will touch upon a few cases, but the most famous and also the impetus for the Annex 6 negotiation was 1989 Argentinian transport ship wrecked in Antarctica, famous Bahia Paraiso fuel spill case. But it's a rare cases. Okay. So what is the policy significance of the Annex 6 and also that Annex 6 becoming effective? Annex 6 is only a small yet important building block, first step, you can say, towards a better protection of the Antarctic environment by providing legal incentive for the operators organizing Antarctic activities to take necessary response actions to and not to abscond from the environmental emergencies they caused. For this objective, and taking into account the unique factual and legal settings in Antarctica. Antarctica is very far away. You don't have much of facilities there, infrastructures. And of course, you have to remember Antarctica is based on Article 4 of the Antarctic Treaty, which shelves the territorial disputes in Antarctica. So because of that uniqueness, Annex 6 introduced an innovative liability regime to pay the equivalent cost or money into the fund, even no one takes the response action. Because of that, with maximum flexibility, this is a word from the report of the chair of that negotiating group. So the Annex 6 provides a lot of flexibilities for the consultative parties to how to implement domestically this Annex 6. Okay, so this is especially Article 6, Paragraph 2b, liability, and also Article 7.3, a mechanism for domestic implementation. Legally speaking, two concepts or two stages should be distinct. The first is the approval of the Measure 1, 2005. Measure 1, 2005 is the measure that adopted the Annex 6. And the consultative parties must approve this Measure 1, 2005, Annex 6, in order for this annex to become legally binding. So this is one process for the consultative parties to make it happen at the international level. And logically speaking, after this Annex 6 becomes effective, meaning legally binding, then the consultative parties need to implement domestically, because Annex 6 will not have the legally binding effect for the country. So legally speaking, usually the approval process comes first, and then the domestic implementation as a sine qua non for Annex 6 obligations to be operational and effective, because liability regimes involves a lot of intricate domestic jurisdictions who would take the obligations, and so those issues must be implemented through the domestic legislations. Okay, so this is the consultative parties and non-consultative parties when the Annex 6 was adopted. So we have 28 consultative parties, And we need to have the approval of all those 28 countries, consultative parties, for this annex to become effective, legally binding internationally. And what is the situation today, 2023, Antarctica Day? We have many approvals already. However, 9 to go. And as you can see, why it's automatic things, huh? Yeah. As you can see from Asia-Pacific regions, all of 4 consultative parties have not yet approved them. So that's the reason Chul and I thought that we come together and how we can overcome this issue. Of course, the United States, for example, Argentina, very important players, they have not yet approved it. But we are close, very close to the adoption, the Annex 6 becoming effective. Okay. I'm sorry. All right, and the second policy significance of this annex becoming effective. I think this is very important for the confidence in the Antarctic Treaty system itself. The fate of Annex 6 will have huge impact on the perception of the consultative parties and other stakeholders on the current and future resilience of the Antarctic governance under the Antarctic Treaty and its Madrid Protocol to address new and emerging challenges. There are a lot of challenges. This is only one, but if we cannot make it happen, how can the system can work for the future and emerging other challenges? So Australia in 2023 said entering into force of Annex 6 would be a milestone for the ATS. I think it is. And there's another issue, the fairness issue amongst the consultative parties. In 2005, this Annex 6 was adopted by the agreement of all consultative parties. The consultative parties meeting runs by consensus, meaning unanimity, and unless you have the agreement of all 28 consultative parties, that annex has not been adopted at all, but it was done. So there was a lot of substantive compromises on all sides, but it was done, okay? Adopted several decisions afterwards by consensus over the past 18 years, reaffirming its becoming effective in timely manner. So we have about 3 or 4 decisions adopted by consensus of the consultative parties that we are going to make it happen in timely manner. How long is the timely manner? We have spent already 18 years since the adoption. And also, many consultative parties already enacted their domestic laws to implement it. So raising fundamental difficulties today seems to contradict with the good faith principle embedded in the Antarctic governance, Antarctic Treaty governance based on consensus. And I have to mention, being an Asian also, so far, the Asian consultative parties tend to be the ones who are later in approving those measures. For example, Japan was the last one to ratify the Madrid Protocol. And I have to say that India was the last one in order for the Annex 5 to become effective. So I think we, the Asians, have a lot of responsibilities to make it happen. Don't you think, Yitong? Thank you very much. All right. Okay. Oh, I'm sorry. Again. All right. So this is the graph of the cumulative approval status. So we started from the 1 in 2005 or something, and we had a surge of many consultative parties approving it in 2012 and 2013, and I'm hoping this workshop would have another surge of the Asian countries approving it, so that this Annex 6 will become effective as soon as possible. So, Ville, you have the floor for more of the substantive details of the Annex 6. Thank you.
Is it working? Yes. Thank you so much. No, I think. Very good. All right. Thank you, Professor Shibata. And good afternoon, everyone. So First, I would also like to thank the organizers of today's workshop, and I'd like to wish everyone also welcome on my little behalf to this presentation. So I'll pick up from where Professor Shibata left. I'll look into some of the details of the mechanism, how it works in the liability annex. This will be a recap for all the legal experts who are familiar with the mechanism, and for those who are less familiar with it, it'll be a brief introduction. In a broader sense, establishing environmental liability in Antarctica is, in my opinion, a three-tier process. The first step was the negotiation of Annex 6, and that was done, as we heard. We are now in the second stage, which concerns the implementation of Annex 6 right now domestically. There's also a third tier, which regards that there are going to be certain talks that will take place after Annex 6 has been implemented, and there will be developments in the liability front perhaps in the future, but those remain in the future as long as we are here in the middle part. We're focusing on the implementation of Annex 6. The liability regime in Annex 6 is focused in its scope to environmental emergencies. So it's not a comprehensive regime for all kinds of environmental liability, but rather it focuses on emergency events. Any accidental event that results in or threatens to result in significant and harmful impact on the Antarctic environment. So these are major events. A typical example would be an oil spill or similar grand-scale environmental accident. The primary objective of the liability regime is to require the operators in Antarctica to take prompt and effective response action to emergencies arising from their activities. So that's the primary objective, to make sure that all emergencies are being addressed properly. The liability mechanism itself acts more as an incentive or an enforcement mechanism on the background as a fallback. Should it happen that an operator does not respond properly to an environmental emergency, then states may respond on the operator's behalf. The operator, in turn, will be liable to compensate for the costs that such a response action incurred. In these activities, the party of the operator, the sort of home state of the operator, has precedence. They have the first right to take these actions on behalf of the operator. Should it happen that an operator or no one else takes any response at all, then the annex includes a provision according to which the operator shall be liable to pay the costs of the actions that should have been taken. And these costs will be paid to a fund. The logic here is that the annex wants to reduce the incentives to abscond or to not report and hide away any environmental emergencies. The liability regime has a limit of liability. The limit is determined in a maximum sum of money. For emergencies concerning ships, the maximum sum is determined by the tonnage of the ship. The larger the ship, the bigger the limit of the liability. For everything else, it is 3 million special drawing rights. That is 3.7 million euro or 590 million Japanese yen approximately. States are not liable for non-state operators if they have been duly compliant to Annex 6 in general, in terms of implementing it and making sure that all the provisions have been followed. The non-state operators shall have to have proper insurance, and for that regard, the annex provides that states need to make sure that they have proper insurance. Having a limit of liability ensures that there should be insurance available because it's possible to calculate the potential costs. Here we can also make reference to Measure 4 out of 2004, Insurance and Contingency Planning for Tourism, which also is not enforced, so states sometimes implement also Measure 4 in conjunction with Annex 6. That measure concerns insurance for tourist activities, search and rescue, safety, and so on and so forth. States, when we're talking about state operators, such as national Antarctic programs, states may continue to self-insure their operators. So states can bear the risk and responsibility of the risk of liability on their own. They don't need to take private insurance, of course. Liability actions refers to legal action taken after a state or another party has taken a response action on behalf of an operator. In case of non-state operators. There are provisions in Annex 6 that require parties to ensure proper jurisdiction and enforcement mechanisms so that any parties that have taken response actions have a possibility of claiming compensation from the operators who should have acted. When it comes to state operators, the liability for responses by other parties shall be settled between parties, so it is a state-to-state situation, so it will be dealt with in an international legal state-to-state setting. The same thing happens when there's liability for damage and nobody has reacted to it. The idea of the question of how much should be paid to the fund shall be determined at the Antarctic Treaty consultative meetings. And for these questions, for these state-to-state questions, the Antarctic Treaty and the Environment Protocol have their own provisions about dispute settlements, arbitrations, and so on. I have compiled a little list of the little provisions that you find in Annex 6 with the phrase, each party shall require its operators to, and each party shall. Those are the magic phrases that list out about 8 primary things that states should have on their agenda when they're implementing the Annex. It's like a to-do list for the states. I should not read it through. When it comes to domestic implementation of Annex 6, broadly speaking, states will adopt the obligations following from Annex 6 and accept them as valid in their legal system, and when necessary, they strive to adapt their existing legislation to accommodate the Annex 6 provisions. Methods vary between countries. This is the maximum flexibility situation we mentioned, but some typical components include the passing of a new implementation statute, a law saying that Annex 6 is now approved, making amendments to pre-existing laws, and especially Antarctic environment protection statutes. So many, if not all, parties to the Environment Protocol have passed domestic environmental protection statutes concerning Antarctica after the Environment Protocol entered into force, and that is a typical statute that gets reformed when implementing Annex 6. Also, there can be amendments to criminal laws insofar as states want to impose fines or other sanctions for people violating regulations in Annex 6 or elsewhere. Entry into force of the implementation measures varies. Some of them have already entered into force as they have been passed into laws. Very typically, though, measures of implementation enter into force when Annex 6 itself becomes internationally binding. So states have set everything up, it's good to go, but they may be activated then when the Annex itself has been approved by all the signatories. Now, I mentioned that there shall be some future questions. These are perhaps not on the table today, but just to point out that already from the Annex 6, we have some of the points that on the agenda in the future as well. Most importantly, Annex 6 provides that the ATCM shall review the limits of liability every 3 years. Well, that has not happened, but in principle, the Antarctic Treaty Consultative Meeting is expected to discuss and revise the limits of liability if necessary. So they're not fixed in stone for eternity, but rather they're meant to be revised. Insofar as there might be state-to-state discussions and negotiations about particular liability cases, over time there might be then reason to look closer into the inquiry procedures and the passing of ATCM discussions concerning liability. And finally, the Annex 6 includes the institution of a fund in which some of these payments will be directed, and that would be administered by the Secretariat, and there is a reimbursement procedure. Obviously, in time, these would have to be established more closely as to how they work. That was my brief run-through of the mechanism, and I thank you all for your attention.
We are on time, so two previous speakers set the scene, set the stage very well. So now we are ready to listen to views and hopefully progresses. We have first China, and then India, Japan, then Korea. Professor Li Chen, would you be able to start now?
Okay, thank you. Okay, before I make a presentation, I would like to send my sincere gratitude to Professor SHIBATA and the organizer to invite us to be here to attend the workshop on Antarctic governance, especially focus on the Annex 6. I think this is a very interesting topic, and it's very important to discuss this issue. And I think it's the time to discuss this issue. It's very important. And me and I and my colleague, we will discuss this issue from the Chinese perspective. So the title is, Has China Well Prepared for Implementation of Liability Annex Domestically? Okay, so this is the question. So after the presentation, I will try to give a conclusion. Okay, so this is the outlines of this presentation. The China's general reviews towards Annex 6 from both official and academia. Number 2, that's the current implementation scheme of the Madrid Protocol be utilized or developed to implement Annex 6 in China. And the last one is remaining issues or difficulties legislative process need to be overcome for China to approval Annex 6. Okay, first of all, the general overview towards Annex 6. From the officials' perspective, so far, there's no published discussions or comments on Annex 6. I tried to find, but no way. Okay, so, and then from the academia perspective, I have found around 10 related articles on this issue. However, that means this issue is rarely discussed in China. And most of the articles, they mainly give a general introduction to the Annex 6. So I just found a very interesting article, the new one. The name is Legislative Activities of Antarctic Treaty Consultative Parties on Implementation of Annex 6 on Environmental Protection to the Antarctic Treaty. So a very long topic. So this one is more close to the topic we discussed today. But the author, he just tried to make a comparative study and mainly introduce the other countries, how they implement Annex 6 into their own domestic law. And from the academia perspective, I found that the general conclusion is that the academics, they are very positive or supportive for the implementation or approval of Annex 6 in China. So generally speaking, the implementation of international treaty in China, we adopt 2 approaches. Number 1 is directly application or incorporation of international treaties China ratified, such as the 1958 New York Convention on Mutual Recognition and Enforcement of Arbitral Awards, or the 1980 CISG. So this is number 1, the first approach. The second one is indirectly application or implementation of international treaties in China. It's called transformation instead of incorporation. So Madrid Protocol in general will be transferred into the Chinese domestic law instead of directly incorporation. So my question here is Annex 6 different from other annexes in nature? Is liability annex concerns civil and commercial matters, especially civil matters and not commercial one? Or it's a hybrid of administrative and civil one? My observation is that I think it's a hybrid combination of civil liability and administrative one. And then I give you the legislation hierarchy in general under the current Chinese law, the legislation law of the PRC. So you can find the hierarchy of the Chinese law. The top is the constitutional law. Then it's the laws by the National People's Congress and its standing committee. And the next one is the administrative regulations by the State Council And then it's the divisional regulations. So the Chinese law implementing Madrid Protocol and the effective 5 annexes now stop at the first level. The first level, that means the divisional regulation. So far from 2014 to 2018, we have 4 different regulations implementing Madrid Protocol and its annexes. Okay, so this is the hierarchy of the Chinese law. So the difficulties under the current schemes is as follows. The hierarchy for current domestic Antarctic rules are lower. So China adopt, as I mentioned, divisional regulations rather than law by the People's Congress and its standing committee to implement the protocol and its effective annexes so far. And based on the legislation law, the competence of SOAs, that means the state ocean administrative, okay, in charge, is restricted and limited. It can only make regulations within its competence. And its competence is highly restricted and limited. So Annex 6 is an international document combined with administrative matters, like the preventive measures, contingency plans, etc., and the civil matters, like the liability and the civil actions, exemptions from liability, something like that, and also insurance in nature. So the civil nature and actions under Annex 6 is far beyond the regulation-making competence of SOA. So this is the relatively articles under the legislation law of the PRC. You can see by laws, the following matters will be governed by the laws of People's Congress. So the basic issues. Article 20 tells us what is under the domain of the administrative regulations. And the justice system is excluded from the administrative regulations. Article 91, you can find that. It provides that like SOA can only develop rules, regulations within their respective competence. So it's very limited. And this is the main issue. I think the hierarchy of the regulation implementing the Madrid Protocol is lower in China. And the second, other difficulties or challenges, I think, is the difficulties on how to, on the so-called private international law, how to interface the Chinese private international law with Annex 6. This is the second difficulties, I think. So according to Article 7, Sub-Article 2, and Sub-Article 3, China has the obligation to ensure that to designate the jurisdiction, the court, and to enforce Annex 6 domestically, right? However, in practice, if you can find that, first of all, if one of the operator bring a lawsuit before the Chinese court, first of all, the Chinese court will try to qualify the liability under Annex 6. What is Annex 6, the liability refers to? It's a tort liability, or it's just like, I don't know how to pronounce this. It's a Latin words. And I don't want to repeat it since it's very difficult to pronounce. So what's the civil liability qualification? This is the first role of the Chinese court. Is tort or anything else? And the second one is the difficulties on the jurisdiction, on the lawsuit. And China just have the new amendment of the CPL, Civil Procedure Law, and the Part 4 relates to the foreign-related civil litigations. And regarding the litigation jurisdiction matters, we can find that Annex 6 require that the court where the operator is incorporated or has its principal place of business or his or her habitual residence. But we know that the court where the operator is incorporated means the nationality of the operator. But this is not the legal basis for Chinese court to determine its jurisdiction. Okay. However, the principal place of business or the habitual residence, China do recognize that this is the legal basis for Chinese court to determine its own jurisdiction. So the second one. The third one is the applicable law rules. As I mentioned, we have to qualify or classify the liability occurred in Antarctica. Is it tort or is a negotiable gesture? Okay, so Article 47 and Article 44, respectively, provides the conflict rules to govern the foreign-related the tort claim or the negotiable gestures in China by the Chinese court. So they share some common rules. First of all, the parties, they are free to choose the applicable law. They're free to choose the applicable law. If there's no choice of law between the parties, then for the first one, under Article 47, the execution of the work occurred. That means the law of the place where the response action had taken place will be applied. But we know that in Antarctica, the sovereignty territory is freezed up. Okay, so there's no so-called Antarctic law can be applied. So this is one problem. So if the liability occurred in Antarctica under Annex 6 is under the domain of Article 44, is classified as tort, then the last resort is the law of the place of tort. It's also in Antarctica. So how to resolve this issue? So we have to figure out. Okay, so this is the third one. And to implementing Annex 6, if the party bring a lawsuit before the Chinese court, we also meet some other difficulties. For example, the evidence collecting. How to prove the evidence collecting? No one will enforce. The officials cannot go to the Antarctic to collect evidence, right? So this is another difficulty. I think this is the difficulty many countries, they will also meet. And the judgment enforcement. For the evidence collecting, we know that there is a Hague conference on taking evidence abroad, right, made by the Hague conference. But this one cannot be, since we know the evidence is in the Antarctic, so it's very difficult to apply that convention, okay? So we will also meet the difficulties on the judgment, mutual enforcement, recognition enforcement of judgment. Okay, so main difficulties in conclusion. In recent years, China has incorporated the main provisions of the protocol with the 5 effective annexes, including the scope of application, the authorization or permit, the EIA, and the supervision into domestic laws as a responsible and accountable ATCPs. However, the regulations implementing the protocol are problematic on its lower hierarchy and the limited regulating-making competence of SOA. So Antarctica as a global common or the public place also bring dilemma to Chinese private international law to be linked up with the rules established under Article Annex 6. So step towards approval. Under Article 10 of Annex 6, China will assume potential state liability if China does not take appropriate measures within its competence, including the adoption of laws, regulations, etc. To avoid the potential state liability, China should first adopt laws or regulations which will leave the space for implementing Annex 6 or incorporate it directly under the current implementing schemes. So considering approve it, it's not possible to approve Annex 6 first without well-prepared domestic laws. This is my personal opinion. So the approaches we can adopt, okay, to overcome the difficulties, 2 approaches, bifocal approaches to overcome the difficulties. The first one, and I also think is a preferred option, is the long-run option. For the purpose of incorporate enforcement obligation, the current regulations implementing the protocol need to be upgraded from the divisional regulations to a comprehensive law made by the Standing Committee of the NPC, and leave the space for implementing Annex 6. So like the US, I remember the US adopt this way. And a comprehensive Antarctic law has been planned, actually, by the 13th Standing Committee of NPC in 2017. So this is the first option. The second option is the short-run option, and I think it's also possible, but it's still, we will meet a lot of difficulties. Amend the current implementing scheme, either by a separate regulation or by revision of the management regulation. Incorporate the administrative obligations, the administrative part, under Annex 6, such as the obligation of preventive measures, contingency plans, response actions, etc., and also the legal mechanism for money collection for the non-state operator contribute to the fund, etc. And then interface the Chinese private international law, including conflict of laws and the CPL with liability action. Under Annex 6, we can, through the SPC, SPC means the Supreme People's Court of China, by the judicial interpretations. So I think this is the short run, and can also, the second approach is just under the current implementing schemes. So let me see. Yeah, that's my preliminary thinking about how to implement the Annex 6 in China so far. Thank you very much. Thank you.
Will Professor Chen Yitong will add on to that.
Hello? Okay.
Okay, go on, please.
Thank you to professors from Japan and Korea for inviting me to come to this meeting. And I think, yes, it is really the time for us, for our Asian colleagues, to talk about Asian countries' participation in the Antarctic Treaty System and further domestic legislative preparations for better implement the environmental protocol. So I will follow Professor Chen Li's topic and similar logic, and I will give my further thoughts under this topic. Could I use the next page? Thank you. So my presentation will be finished in very short minutes, in 5 minutes, so interrupt me when the time is up. So basically include 3 parts: the facts that I observe, and the suggestions I want to give, and a little recent information for the developments. So first is the fact. I think the incremental legislation model is very typical in China for when China ratified the international multilateral conventions and agreements, and then to transform and incorporate the international obligations into domestic laws. So basically, I think there are 2 categories. So the first category, that is, first, China will adopt a comprehensive and higher level, so which I call it law, and then will issue several detailed and low level, we call it regulations. So this is the, so I will give the example here for the multilateral conventions here. So China ratified the CBD, the Cartagena Protocol, and Nagoya Protocol at the first time, and the year I gave you, not the ratifying, so that is the year for China ratified the CBD in 1992 and ratified the Cartagena Protocol on biosafety to CBD at the first time in 2005, and also the Nagoya Protocol in 2016. And after the ratification of these international agreements, so China issued a comprehensive law to obey its international obligation. That is, so I give the example here. So the biosecurity law, so China issued in 2020, and this wild animal conservation law. So the adoption year, that was in 1998, but to incorporate the international obligations from this biodiversity convention and agreement. So China amended the wild animal conservation law for 5 times. And then after this comprehensive law, so China issued the draft regulations on access and benefit sharing of biological genetic resources, but in 2017, but it's already 6 years, but it is still on the way as a work as a draft, so has not become a become a formal regulation. And I will give example B, a second example here. That is, we are quite familiar here. That is the law on exploration and development of resources in deep seabed areas in 2016, because China is a country and party of the United Nations Convention on the Law of the Sea. So to implement this obligation, international obligation. So this is the comprehensive law, right? And then after this comprehensive law, in just 1 year, very, very quick, so China issued 3 interim measures working as supplement regulations to support this comprehensive law. So interim measures for data management and for sample management and for the administration of licensing in just 1 year. So this is a very efficient legislation experience. So. And this is the second category here, from the detailed and lower level, so from regulation to comprehensive and high-level law. So example A here is the UNF. So China ratified as soon as possible at the first time for the UNFCCC, the Kyoto Protocol and Paris Agreement at the first time. And then to implement these international agreements and conventions, so China actually issued various climate-related laws and regulations, but the whole comprehensive climate law is still on the way. And there indeed was a draft issued by still a draft from academy in China in 2008. So it's a long time, but it is still on the way. So, and the related climate law, so I give some example, but there are much more, okay? So the first related law, that is the energy conservation law in 2007 and the renewable energy law in 2005. And we know that China, the central government, announced the dual carbon strategy in 2021 for achieve the goal of the carbon neutrality and carbon peak. So, and issued the white paper, but it is not a law, right? In 2021, combined with the dual carbon strategy. So responding to the climate change, China's policy and action. So Antarctic here, so I give as an example B. So we do not have a comprehensive law like Professor Chen Li just said. So, but instead we have some regulations. So I will not repeat the name because just now we already know that. So this is the suggestion part. So as myself, as an individual person, so I will give the whole suggestion here is, speedy enactment of Antarctic legislation is a must at this period for China. So I will give my personal option here, 2 options. The first option, that is to issue the Antarctic legislation in a top-down approach. So, and my comments here is it's a high probability. So it's probably in this way. So what does it mean? So China should, so as a personal suggestion here, so China should issue the Antarctic comprehensive law, and this comprehensive law should include the Annex 6, the content of Annex 6, and especially the part of the transform the preventive measures, the contingency plans, the insurance part, and into the administration of licensing part. So, and established some content as a special part or detailed clauses, several clauses for the content of prompt and effective response, and established a special part or established some clauses, including the liability. And so this is the domestic legislative arrangements. And after the Annex 6 is effective globally, so the future regulations from China's side could issue some regulations to support and improve this whole comprehensive Antarctic law, for example, for supplement the part for the fund. And the option 2 here, that is the approach of bottom-up approach, and I think it is unlikely. For example, China issued a specific regulation to incorporate the Annex 6 into the domestic legislation, and then after this, and when China is ready for the comprehensive future Antarctic law, okay, that is the follower things. But why I think it is unlikely, because I think Annex 6 is much more complex and cross-cutting than other annexes compared with the other 5 annexes, and it will increase the difficulty for issue this specific regulation, because like Professor Chen Li just said, the SOA usually is the agency for issue this kind of regulation, and it will give there too much burden here. And without the specific principles, the contents, the structures, and scope of applications should be appeared in the comprehensive Antarctic law, the SOA will feel, okay, it is too hard for them to issue this kind of specific regulation. And this is the last point here. So the recent development. So in November 2020, the 68th meeting of the Standing Committee of the 13th National People's Conference already included the comprehensive Antarctic legislation in the 2021 legislative work plan. Before I came here, so I checked the recent news. So it is still, this work, it is still on its established track, but the news actually issued last year in October 29, 2022, according to a report of the Environment and Resource Protection Committee of the NPC. So I quote it here. The legislative plan and annual legislative work plan of the current NPC standing committee suggest that keeping drafting and researching for this, call it comprehensive Antarctic law. So the law of the people's, so the China's Antarctic activities and environmental protection. So it is still a draft, but already was formed. So it has been deliberated by plenary meeting of the committee and will be submitted to the Standing Committee of the National People's Congress for deliberation in due course. But I think many people want to know. We do not have the timetable here. So thank you so much.
Thank you. That was very interesting, intriguing. And might I invite Kanagavalli to speak on Indian progress, please?
Yeah, thank you so much. In the given short duration of time, I will try to present India's position. India recently passed a comprehensive legislation, the Indian Antarctic Act, in 2022. So this act was passed in order to provide for the national measures for protecting the Antarctic environment, dependent and associated ecosystem, and to fulfill India's obligation in the Antarctic Treaty, KARI, and the Environmental Protocol. So this also includes a few provisions on Annex 6, the liability arising from the environmental emergencies. So I would begin with a short introduction on India's Antarctic journey. India's first Antarctic expedition dates back to 1981, and India signed the Antarctic Treaty in 1983, and it was accorded the status of consultative party. And it also ratified the KARI on 17 June 1985 and signed the protocol on 14 January 1998. So India currently has 3 research bases, out of which 2 are operational, which is Maitri and Bharti. And recently we had the 43rd scientific expedition, which took off to Antarctic from India. So this is for a brief introduction on those who don't know the Antarctic program of India. And these are the 2 bases that is operational, Maitri and Bharti. And these are permanent bases, and India conducts research on atmospheric science and paleoclimatology, and they study the change in structures and phytoplanktons and zooplankton. Many other research activities are conducted. As I mentioned earlier, the Indian Antarctic Act has been passed to provide for national measures for protecting the Antarctic environment and dependent and associated areas. According to Article 13 of the protocol, the Environmental Protection to Antarctic Treaty, it is incumbent on the state party to undertake appropriate measures as may within the competence to include adoption of laws and regulations and administrative actions and such other enforcement measures to ensure compliance of the provisions to this protocol. So the Antarctic Act was passed by both houses of parliament and received the assent of the President of India on 6th August 2022. So in summary, the key provisions of the Act deal with various activities that are prohibited from being conducted in Antarctic. It has established a committee, which is the apex decision-making body, that shall be permitting authority in granting approval to conduct the permitted activities. And it also delineates provisions for waste management, emergency plans, and it also has some provisions relating to the liability of the environmental emergency and emergencies in Antarctic in general. And it also establishes offenses and civil penalties for violations and sets up trial codes for conducting proceedings. So it would be very difficult to go in detail with each one of it. I will try to touch upon the relevant aspects in the upcoming slides. To whom does this act apply? It applies to all Indian citizens who are part of the Indian Antarctic expedition or any other foreigner who are part of Indian Antarctic expedition but do not have obtained any authorization from other party to the protocol. Additionally, it also applies to vessels, aircrafts engaged in Indian Antarctic expedition or vessels or aircraft that is registered in India but a part of expedition of another party to the protocol. So it applies to the Act, applies to whole of Antarctic region, including the Kamilar regions, which includes the whole of Antarctic, including the ice shelves, all islands, air and sea space south of 60 degrees of south, and all continental shelves adjacent to the continent and the islands. The implementing authority is the Committee on Antarctic Governance and Environmental Protection, under the auspices of Ministry of Earth Sciences, is designated as the apex decision-making body. It shall be the implementing body in facilitating programs, granting permits to allow activities to be conducted in Antarctic as permitted under law, and ensuring adherence to relevant rules and international standards on activities that are conducted by India and Antarctic. I will discuss later regarding the constitution, powers, and functions of the committee. So the Chapter 3 of the Act specifically deals with the prohibitions. So it prohibits any person from carrying out any nuclear explosion or disposal of radioactive material, introduction of non-sterile soil, and or any specified substances or products, damaging, destroying, or removal of any historic sites. It also bans any person from or vessel or aircraft while in Antarctic from possessing, selling, or transporting anything in contravention to the Act. So also no vessel shall discharge or any garbage, such as domestic or operational waste, plastic, or any other product that is harmful to the marine ecosystem. These are punishable offenses under the Act, and which includes both imprisonment and fine. For example, anyone who commits violation of Section 17 of the Act, that is the nuclear explosion, will be punished with an imprisonment of not less than 20 years, and it can extend up to an imprisonment for life, and fine of 500 million Indian rupees. So this is the Committee on the Antarctic Governance and Environmental Protection, and it's the apex decision-making body. This is established by the Central Government of India, and the Secretary of the Ministry of Earth Sciences is the ex officio. member of the committee. And there are 10 high-ranking officials who would be on board from Ministry of Defense, Science and Technology, Environmental Ministry, and so on and so forth. There are also 2 nominated members who are experts both in the field of Antarctic environment and geopolitics, and such other experts may necessarily be included into it. So the function of the committee is to monitor, implement, and look at the compliance of international law, emission standards, rules of protection of Antarctic by operators and by other persons engaged in various activities in Antarctic. So it is also to engage, obtain, and review the reports from other parties who are engaged in various activities in Antarctic. The committee will ensure that the compliance of all India's activity in Antarctic comply with all international legal obligations and comply with the Antarctic Treaty, Protocol, and Convention. So it is crucial, it also has the crucial function to determine the terms and conditions of the permit that would be issued under the Act. And Chapter 5 specifically deals with grants, suspension, and cancellation of the permit. Every applicant for the grant of permit is made to the committee along with the prescribed fees, and the committee takes into consideration while granting the permit on issues such as how the various adverse effects on climate and impact on ecosystem, changes in atmospheric and terrestrial marine impact, noise, and so on and so forth. So this all such significant detrimental impact on Antarctic environment dependent on associated region needs to be considered. So before the issuance of the permit, the environmental impact assessment is conducted, and if all the procedures are followed with respect to if it is a minor or transitory impact, such an application needs to be made 6 months in advance, and the committee with an expert opinion then goes into deciding whether it's an initial environmental report is required or it has to go in for a comprehensive report. So the committee has powers to cancel, suspend, or revoke the permit if, on reasonable grounds if found violating the provisions of the Act. So this is on the committee, and it also grants permits. So no person can enter in Antarctic or any or Indian station in Antarctica, or any vessel that is registered in India can remain in Antarctic without the valid permit. And also no permit is provided to any exploration or mineral resource activities unless the committee is satisfied that is solely for the purpose of scientific research or construction or maintenance of Indian station or infrastructure. So these are all various factors that are taken into account while giving the permit. And also, no valid permit is provided without a waste management plan and emergency plan in place by the committee for any expedition. There is a strict regulation on waste management plan for the 2 operational research bases. The committee shall establish waste classification system, prepare, review, and update the waste management plan. And waste management officers are set up in every station who are responsible to implement the waste reduction and disposal plan. So as far as the emergency plan is concerned, it refers to the environmental emergency, that is Section 39(1) of the Act. So this is a specific section that deals with the environmental emergency, Section 39. So the environmental emergency for this purpose is something similar to what the definition we find in Annex 6. So it says that it's defined as unforeseen or accidental event that results in or imminently threatens to cause a significant and harmful impact on the Antarctic environment. So if any such environmental emergency occurs in Antarctic or its dependent or associated region, so the operator needs to take immediate response action without any delay and inform the committee and also the Director General of the Merchant Shipping Act of 1958. This is the specific provision that's there on the environmental emergency. And it's also the committee needs to transmit the information to the parties of the treaty. If no response action is taken by the operator, and if the nature of the emergency is immediate, then the party where the vessel or the aircraft is registered need to take immediate response action, and the operator need to pay the cost of such response action to the party or parties of the as per the Annex 6 of the protocol. And if both operator and the party or the parties do not take action, the operator needs to pay the penalty as prescribed under Annex 6 to the protocol. Section 40 speaks about the exceptions, such as the where the environmental emergency, the operator is not liable for the environmental emergency, such as the act of God and terrorism and an act of war against the operator, and so on and so forth. So this is the one specific provision that that is there in the Act, specifically on the environmental emergency. And the Government of India, in consultation with the Chief Justice of High Court, can designate one or more courts that shall have jurisdiction to try the offenses in Antarctic. These courts can try the offenses committed under the Act in Antarctic as deemed to have been committed in India. So the whole chapter is dedicated towards the penalty for contravention of the provisions of the Act. There are several levels of punishments depends on the gravity of the offense. So in case of environmental emergency under Section 39, if a vessel is involved, then the operator, and it's found contravening the provisions of the Act, then the operator of the vessel is punishable with an imprisonment of term for 7 years and a fine between 20 million to 100 million Indian INR. And the central government also can frame rules to carry out the provisions of the Act, including the cost of response under Section 39(2) and the penalty that is to be paid to the operator under 39(3). And also, when an expedition is carried out, there is the Antarctic Fund. There is a need to park an amount of 5 to 10% of the cost of the expedition as a security deposit towards the Antarctic Fund. So this is the whole comprehensive act that's been recently passed on the Antarctic. Thank you.
Thank you. I'm certain you would have questions, but we are going to save the questions and wait until the discussion after 5:30. Now, time for Japan to contribute.
Okay, so at first, my name is Satoshi from National Institute of Polar Research, Japan. So I'm not a lawyer, but just a biologist studying Antarctic terrestrial plants. So I will tell just a little from the point of view of field scientists and soon take the seat to Professor Shibata. And our institute have a no lawyer section and completely composed of natural scientists. So, to be honest, we did not discuss enough on the status of consideration of this Annex 6. But as an institution carrying out the national projects of Antarctic research, we have a system to place to make an international report and take measures to deal with the events. Even the slightest environmental pollution incident occurs. Although there were some small-scale oil spills, contaminating snow and soil were removed quickly and completely. And when oil leaked into the ocean, long-term monitoring of the degree of contamination have been carried out. If it is impossible to respond domestically and foreign countries is asked to respond, we think the government will pay the cost. Also, the government is expected to take a responsible approaches also to tourism board, which Japan prioritizes. We hope that the prompt entry into force of this annex will put Japan in a position to fulfill its international responsibilities. So,
thank you, Imura-sensei. That was very encouraging word from a very important person in the Japanese Antarctic expedition scheme. And so I'm very, very happy to hear that. Thank you very much. So I'm a lawyer, and so I am going to discuss how Japan would be able to implement the Annex 6 domestically. Okay, a lot of words. I'm sorry about that. The lawyers tend to be like that. But so I'll go through the slides. Basically, I'm reading out of these slides. So thank you very much. Japan has a very, how do you say, honest attitude towards international obligations. So when we consider, we means Japan considers domestic implementability of any treaties, including Annex 6. Japan, takes a very, very, very careful approach to examine before that instrument becomes binding on Japan, in this case, approving it, Annex 6. So this shows Japan's serious attitude towards international obligations. I think that's very good. At the same time, this examination on domestic implementability may become a very theoretical, hypothetical exercise, and there could be a danger of being too perfectionist. And we have in Japanese word kanzen shugi, kanzen kokunai jisshi shugi. So this is the word for Japanese, actually explaining the Japanese practice of implementing international treaties domestically, and this word perfectionist is actually used by those responsible in the foreign ministry that they are doing in a perfectionist way. But in this context of the Annex 6, I consider rather a more practical and realistic approach may be warranted. How Japan would do that? I think Japan can consider some practical case studies where we would realistically face, rather than considering all possible potential cases that Japan might consider in the future. And I think those are the three cases where we already had ones where that might become a obligation for Japan. The first is, of course, this is a major, I think, the activity of Japan, which is the JARE, so Japanese Antarctic Research Expedition, including an icebreaker using Shirase, which is operated by Japan's maritime self-defense forces. The second is a cruise ship. So we had Asuka number 2, which was owned and operated by Nippon Yusen, so a Japanese company, and flagged to Japan. So it's very clear case of Japanese tourist cruise ship going to Antarctica. So this happened only once, actually, in 2015 and 16. And Nippon Yusen does not go to Antarctica anymore. So it has happened in the before, but it's not happening today. And the third is the, I think, more likely cases in the future. A small team, this is the NHK TV team for the documentary filming in Antarctica. And they were on board a foreign tourist vessel, and they organized a filming in Antarctica in about 12 personnel of the group. And the NHK personnel, they got the certification from the Ministry of Environment, and so that this will probably become a Antarctic activity responsible, in which Japan will be responsible to take care of. So I think those are the three cases where we should consider in order for Japan to whether and how we would implement those obligations under Annex 6. So let's take the most relevant case, which is the JARE case. And I think this is a straightforward state operator case. And if you see the structure of the JARE, it's very clear. It is organized by the headquarters, the JARE headquarters. And JARE headquarters is headed by the Minister of Education, Science and Education. So it is a governmental organized activities. And the headquarters uses NIPR, uses the Shirase for the expeditions. So it is the governmental organize activities, and the headquarters actually apply for the certification to the Minister of Environment. And usually they get it, and so that the JARE can go to Antarctica. This is all. This certification process is under the Japanese Antarctic Environment Protection Law, adopted in 1997, in order to implement the Madrid Protocol, the main international treaty. So operator under Annex 6 for JARE, Shirase will be the headquarters according to Annex 6, Article 2C, and Japan will be the party of the operator according to Article 2D, which will be responsible to take several measures required under Annex 6 in relation to JARE activities. The JARE headquarters through NIPR and the self-defense forces must take response actions in relation to environmental emergency caused by them, meaning NIPR and the possibility of Shirase causing some environmental emergency. So this is Article 5. Then, of course, there are other obligations, but those obligations are upon the headquarters, the government, the Japanese government. So JARE headquarters must pay the cost of response action taken by the other parties, Article 6.1. JARE headquarters, in case nobody takes the response action, must pay the equivalent cost of the money towards the fund. The fund is established in Article 12. If JARE headquarters does not pay the cost, which I don't think is the case because it's governmental obligations, I'm sure they will pay it, as IMURA sensei also said. Or maybe the money contributed to the fund was considered by others to be a little bit less than they thought. This is a kind of a dispute situation, so that this kind of discussions will happen in a state-to-state, party-to-party procedures, inquiry, and finally the possibility of arbitration and International Court of Justice, so we can get the legally binding decision on this kind of dispute with regard to the amount of the payment, or whether Japan should pay for it or not. So I think it's a very clear state-to-state dispute procedures and very effective, I consider. Of course, for the Shirase, the sovereign immunity applies. The limits of liability for Shirase-related accidents, the maximum would be that kind of money in US dollars, and the limits of liability for the NIP and non-ship-based activities would be that kind of money, but that's the maximum. That's the maximum. It wouldn't be so if the activities are much smaller, but it's a maximum. And so those maximum amount of the liability is set in order for them to be able to get the insurance. But in the case of JARE, the government can self-insure themselves, so they don't need to buy insurance from private companies. So again, in conclusion, for the JARE case, the direct application of Annex 6 obligations on the Japanese government, that is the JARE headquarters, which is the Ministry of Science and Education, would most likely suffice. Okay, what about the second case, the cruise ship? Again, it was a simple non-state operator case because it's owned by and operated by a Japanese company and flagged to Japan. So it's a very simple case of Japan being responsible for the activities done by ASCA. But in the future, and of course, the NYK is the Nippon Yusen company. They actually, the NYK, established a subsidiary, Crystal Cruises, in the United States of America, to operate another ship, Crystal Symphony, in Antarctica 2013 to 2014. But in such a case, the party of the operator would be the United States of America rather than Japan. So in that way, the Japanese company may have some links with the Antarctic tourist activities, but at the moment, I think most likely it will not be the Japanese company, but the subsidiary of a Japanese company, but in this case, the United States, for example, because Crystal Cruises is established in the United States, will be responsible for the actions required under Annex 6. But going back to the simple case of ASCA, number 2, Japan will most likely implement Annex 6 obligations in relation to ASCA 2 type of cases by applying and supplementing some provisions if necessary. It's Antarctic Environmental Protection Law, so it's administrative law, basically, under the supervision of the Minister of Environment. there is one issue with regard to that law. Non-landing vessels are not currently under the certification requirement of that law. So ASCA 2 did not land, therefore it did not become certifiable activities under this law. But this, I think, according to the Annex 6, all the tourist activities should be within the scope of the Annex 6. I consider Japan may need to consider revising this interpretive practice under the law. The limits of liability for ASCA 2 accident would be a very large amount because it's a huge ship, about 50,000 tons, and it's much larger than Shirase actually, so that this would be the maximum amount of liability, and the Minister of Environment must require the Nippon Yusen company to have adequate insurance. And there, of course, has been some discussions whether there are insurance market available. But I think this is a very international market, and you don't need to get insurance from the Japanese insurance company. So, and other countries are already implementing this Annex 6. I'm sure the insurance will be available when the Annex 6 becomes effective. Okay. Yeah, the third type of an activity. Much smaller team of Japanese people going to Antarctica, in this case for the filming. It will come under the Japanese responsibility if this NHK filming team causes the environmental emergencies because of those procedures that this team went through. Under the law, the Ministry of Environment may legally oblige the operator to restore the original conditions. So it's almost a restoration measures that is already required under the current law, and other alternative measures. This is Article 23 of the law. And when the operator does not comply with such orders, the Minister of Environment may take such measures and make the operator bear all or part of the expenses. It's already there in Article 23. So the basic, thinking of Annex 6 is already there in the current Japan's Antarctic Environmental Protection Law. And the operator can be fined up to 1 million Japanese yen, which is a little bit probably smaller compared to the expected response cost, but it could be raised through revisions. So again, most of the Annex 6 obligations can be implemented with technical revisions. Maximum fine reflects as much as possible the cost of the response action, so there is a flexibility there. So it's just a matter of whether it's within the scope of this flexibility allowed under the Annex 6. The liability limit and the insurance requirement are feasible for such small teams. Yes, of course, that might be a case, but I think it's a very technical issue and can be dealt with sufficiently later. So, in conclusion, tentative conclusion, in relation to JARE expeditions, Japan as the party of state operator can already implement Annex 6 obligations through their direct application. In relation to Antarctic vessel activities, excluding fisheries, without landing in the Antarctic Treaty Area, Japan may need to revise its interpretive practice under the current law to require them to come under the certification procedure. In relation to other potential non-state operators, the current law, utilizing the administrative authorities and actions of the Ministry of Environment and administrative fines or penalties that can also be enforced through Japanese courts, will provide an appropriate basic legal framework to implement Annex 6 obligations, including Articles 6 to B, innovative liability. But it will require some technical and supplementary revisions to the current law. So it is a formidable work for the persons responsible for this issue, but can be done with strong policy commitment. Thank you.
I think we are learning every country has different systems and different cases. Now we will listen to Korea then. Dr. So, are you online? Yes, you can go ahead. Yes, please.
Yeah, do you hear me?
Yeah, we can hear you well.
Yes. Hello, everyone. My name is Wonsang, and I work at the Korea Polar Research Institute as the Director of Strategic Planning. Today's co-chair, Dr. SHIN, is my boss. I would like to express my gratitude to Professor Akiho SHIBATA for organizing such an excellent and important workshop and inviting me to participate. I had hoped to meet experts from many countries in Kobe, but I'm sorry that I am attending online. Yes, let me start to present. Okay. Can you see the full screen version?
Yes.
Yes. Okay. Okay. Let me start to present on Antarctic environmental liability and Korea. This topic is I have prepared in collaboration with Dr. SHIN. My presentation is structured into 4 parts: overview of NX6 and Korea, NX6 and KOPRI, and the conclusion. But I think I do not need to repeat the overview of the NX6, so I will skip over the overview and start with the issue related to Korea. It's page 7. Okay. Yes. Okay. To adopt NX6 on international treaty into Korean law, we first need to examine Korean legislative system regarding Antarctica. The first act on the activities in the Antarctic area and the protection of Antarctic environment was enacted in 2004 to implement the Antarctic Treaty and its protocol on environmental protection, and to actively participate in the international cooperation related to Antarctica. This act focused on protecting the Antarctic environment and contributing to the development of Antarctic science and technology. It allows for criminal penalties in case of violation of regulation regarding the permission of Antarctic activities. Next page is the second act, the Polar Activities Promotion Act, has been enacted 2 years ago. This act was established with the aim of contributing to the sustainable development of polar regions and solving common problems of humankind. It also includes the expectation that through systemic promotion and support of polar activities, it can contribute to the development of the national economy and the improvement of the quality of life for citizens. So after the Polar Act, the Korea's interest in polar policy has expanded from Antarctica to the both polar regions and is extending from science and environment to include economic aspects. According to the Constitution of the Republic of Korea, treaties and rules of international law, such as international custom, shall have the same effect as the domestic laws of Korea. In other words, Korea takes the monistic approach to the international and municipal domestic law, adopting international law as a domestic law without modification or reacting. Nevertheless, I think that Korea needs a domestic implementing legislation to fulfill the obligation of the state as specified in Article 10 of Annex 6. If Korea were to ratify Annex 6, the first thing to focus on should be the role and functions of the Korea Polar Research Institute. Article 2 and Article 2C and D of the Annex 6 present the definition of operator and state operator, and KOPRI is the sole operator of Korea now. Only one operator, the same, and only one state operator, same time. KOPRI performs functions such as scientific research, logistics, and operate the research station in Antarctica. And KOPRI is the government-funded research institution organized under the territory and sovereignty of Korea. KOPRI will be required to undertake reasonable preventative measures to establish contingency plans for response to accidental event as environmental emergency, and to take a prompt, effective response action. KOPRI has already established safe manual and environmental protection guidelines related to the Antarctic research activities, and is systemically conducting education and training. However, response manual on environmental emergency is required in addition safety manual in Antarctica. An operator that fails to take response action shall be liable to pay the cost of response action taken by parties. As I said before, KOPRI is state operator. A party may maintain self-insurance in respect of its state operators, including those carrying out activities in the furtherance of scientific research. The KOPRI operates three infrastructures in Antarctica. They are Sejong Station and Jangbogo Station and ice-breaking research vessel Araon. According to the Article 9.1 of Annex 6, KOPRI needs a total of 9.2 million SDR as a financial security for liabilities. As a conclusion, Korea needs the following discussions for the ratification of Annex 6 and the preparation of implementing legislation. The first is consultation among the Ministry of Foreign Affairs, Ministry of Environment, and Ministry of Oceans and Fisheries. All three ministries are the main governing body for Korea Antarctic Act 2004. The second is to decide whether to enact new implementing legislation or modify existing laws such as Korea Antarctic Act 2004. The third is development of insurance product for operators, not state operators. Discussion on this issue has not even started yet in Korea. Thank you for your attention, and I would like to ask Dr. SHIN additional comment. Thank you.
My colleague Wonsang wrapped up by saying that it hasn't even started. Well, in fact, we conducted a few feasibility or planning studies on this matter, but no concrete proposals were made. And for the state operator or state-supported operator, in our history of almost 30 or about 35 years of our operation, there were no major environmental damages made. I was almost with the beginning of our program, but although some irregularities, there was no major accident, which is okay, which has been good. But the other cases may exist, like we have fishing vessel licensed under the national legislation, and we have some tourist activities too. So for us to be able to come up with some concrete measures that can take place before we do something seriously to this Annex 6. But so far, a small number of feasibility studies, what we have done so far. Okay. Now, I think we're almost on time, so perhaps we will have break 3 minutes extra. This may be an opportunity for you to think of some questions. But after this break, we will hear comments from other parties, including a non-governmental organization, but we made sure that we have time for discussion, at least half an hour. Okay, let's take a break. But the photo will... For the speaker. Okay, all right, thank you. So we'll be back on 5.
Yes.
Okay.
So we will commence our the second half of the workshop, and we will start with comments from the participants. And we have again experts who have the particular knowledge on particular countries' implementation of Annex 6. And we have Professor Ville KARI, who would present on the Finnish and also German 2 cases. So he has 12 minutes. And could you, I think from there, could you? I'm sorry. Okay, and then followed by Ms. Damura Gumuskaya, Consul General of Turkish government from Nagoya, and with Professor Saab Erguven from online will present on Turkey's case, and from online we have Claire Christian, the head of the Antarctic and Southern Ocean Coalition, the non-governmental organization. So can I ask Professor Ville KARI to present on 2 cases? Thank you.
Thank you. Thank you very much. So without further ado, let me start talking. The title said that we would have comments, but we were invited to give some experience, to share some experiences from a few countries that we may know something about. So the first case I just wanted to walk through briefly is the case of Finland. Finland implemented Annex 6 through a legislative proposal that did a few things on one go in 2010. The first thing it did was it included a law or a statute, an act for implementing Annex 6. It was a sort of a blank statute that briefly ascertains that the provisions in Annex 6 shall be forced in Finland as law. This is a constitutional manner of enacting treaties in Finland. The entry into force is in the second article, and according to that, the treaty or the Annex 6 enters into force by government decree. It is to be activated at the entry into force of Annex 6 itself. That's all that the statute contains. It's more of a formal statute. The second and the most important part of the implementation was that the bill or the legislative proposal amended the law on environmental protection in Antarctica. So this is the general statute that applies to Antarctica since the entry into force of the Environment Protocol. The amendments that were here in the legislative proposal, they entered into force in the beginning of 2011, and therefore Finland actually has a domestic legislation for liability provisions of Annex 6, and they already apply to Finnish operators. In addition, there were some minor adjustments to the criminal code, and also this legislative proposal included implementation of the revised Annex 2 and Measure 4 by 2004. I'll focus on the Annex 6 part. In the Finnish implementation, the way it works now in the Environmental Protection Act of Antarctica is that liability and jurisdiction follow the issuance of Finnish Antarctic permits. According to the law, all activities in Antarctica must be permitted by the competent Finnish environmental authority, and then liability consequently applies to anyone attending any activity with a Finnish permit. So Finnish nationals, anyone who has their place of domicile in Finland, also foreign persons who participate in an operation with a Finnish permit. And as a consequence of the implementation of Annex 6, obtaining such a permit requires now proof of compliance with a number of provisions in Annex 6, such as provision of sufficient financial security. A new chapter on environmental emergencies was added into the statute on environmental protection in Antarctica, pretty much verbatim implementing the provisions in Annex 6. I won't go through them in detail, but roughly speaking, that you can clearly see that they are bringing those provisions into the Finnish Act. There is also an Article 35F at the end of that Chapter 6, which concerns procedure and legal actions. So this corresponds to Annex 6, Article 7, and it has been passed to enable parties that would have taken actions on behalf of Finnish operators to claim compensation from the operators as provided in Annex 6. The jurisdiction here, the court here is appointed directly. It is the Vaasa Administrative Court, so it's an administrative tribunal. And this specific tribunal has been named in order to reduce uncertainties about which forum should be applied. By contrast, in the same article, it's provided that no action may be raised against state operators. This is permitted by Annex 6. So Finland maintains self-insurance for state operators, and we know that the procedure for dealing with liability issues for state operators are found directly in Annex 6. It's worth noting that the Finnish National Antarctic Program, FINARP, is pretty much the only relevant operator there, so the Finnish relevant case is that of state operators. But the implementation of Annex 6 provides also for the possibility of non-state operators. Payments that might be made under Annex 6, Article 6.2, are currently made to the State Treasury in Finland. However, the implementation already provides that once the fund has been established, such payments shall be forwarded to the fund. So in summary, looking at the implementation process, I didn't find any massive, significant contentious issues. To me, it seems that the Finnish approach was that once they had agreed on Annex 6 initially, then the state was committed to implement it, and then they carried it out by implementing it as best they could. So there is in the language of the preparatory documents, there's a clear commitment to environmental protection and a conscious acceptance of the liability regime. And the domestic legislation is already there concerning liability, and it's in force. The Implementation Act, the formal act, is still waiting for the entry into force of Annex 6. The case of Germany, I was invited to look at the case of Germany because it was a particular interest to the organizers, so I did so. So here comes a little disclaimer. I'm not a German lawyer, so I apologize in advance to all the German lawyers who might spot my mistakes. But I looked into it, and the German approach was that they passed a new substantive implementation statute. So it was not a blank statute saying that Annex 6 is in force, but rather it is a particular act concerning environmental liability in Antarctica. In practice, it operates jointly with the German Antarctic Environment Protocol Implementation Act, which is the Environmental Protection Act on Antarctica. So those two are relevant. The implementation statute enters into force when Annex 6 does. So it has been passed and it's clear, it's ready to go. However, Annex 6 needs to come into force internationally before the statute is valid. As with Finland, the obligations and jurisdiction are linked to the issuance of permits. So contingency plans, insurance, financial security, these need to be verified before an operator gets a permit from the environmental authorities. The actual implementation of the liability regime, it is again very similar. You can see a kind of a similar structure to other implementing statutes perhaps, and it resembles the Annex 6 contents very much as well. And by my interpretation, again, you see a conscious attempt to seek very close correspondence with Annex 6 itself. Something I wish to highlight about the German example, that the impression that I got from it is that it has this emphasizes this public administrative approach. So a couple of features caught my eye. So in the event of a non-response of a German operator, the German statute of implementation has already an administrative mechanism with which Germany may address the situation firsthand by itself. So as we remember, Annex 6, Article 5 provides that in the event that a party needs to intervene after an operator has not engaged in response actions, they need to reserve the sort of first opportunity for the home country of the operator. So Germany has the legislation in place to do that immediately on its own, to really make sure that it can address issues. And in practice, the Federal Environment Agency may contract with another operator to take the relevant response action. And this can be basic. I suppose that this could theoretically be a non-German operator, just anyone that they make a deal with and assign them to the task of taking care of the response actions, and that will be then done on behalf of the German Federation. Also, whenever that sort of an approach is taken, the Federation may claim the resultant costs from its operator. Very similar to the provisions in Annex 6, but they have made sure that have written it out so that it's clearly there in the law that they can do it by themselves without having to have recourse to the international framework. Similarly, legal actions against non-state operators, should there be such from other parties, they would take place in administrative procedure. That would be the first instance. So instead of going directly into a court jurisdiction, it seems to me that the implementation statute provides that the correct forum is, the correct approach is to lodge a claim with the administrative procedure of the Federal Environment Authority. So in the first instance, foreign party claims are addressed in administrative procedure by the relevant officials. I understand that there would then be an appeals route to administrative courts if there are disputes after a decision has been reached. It must be understood that the administrative procedure at this point, at this scale, it would be a comprehensive and formal procedure with plenty of evidence and examination. So that's the way it works. By contrast, legal actions against state operators are not permitted. So again, here we refer to Annex 6, Article 7.4, the self-insuring of state operators. I found a quote from the preparatory documents that I made a rough translation here of, and I wish to drop that here in the end. According to the preparatory materials, the implementation statute does not contain procedural rules for the enforcement of payment claims by other contracting states against state operators. So the reason for this is that according to Article 7.4 of the Liability Annex, the intergovernmental procedure stipulated in the Environmental Protocol applies directly. These rules do not require individual national implementation and are self-executing. Therefore, they do not require legislative implementation. And so this refers to the fact that should there ever be a dispute about the liability issues arising from German state operators, then those would be dealt with in state-to-state settlements. Those are already anchored in the treaties and the annex themselves. Thank you. Thank you.
Thank you, Ville. That was very interesting, especially the German case, because when I was negotiating Annex 6, it was Germany and Japan who fought tremendously at the very end for the flexibility provisions for the implementation, and I think that actually worked for Germany, and it should work also for Japan. Thank you. All right, then can I ask distinguished Consul General from the Consulate General of the Republic of Turkey in Nagoya, Damla Gumuskaya, to present the Turkish case, and maybe Saab from online can also intervene. Thank you.
Thank you. Thank you very much. My name is Damla Gümüşkaya. I am not here as the Consul General, but as a practitioner, because I used to be the head of Department for Maritime Affairs in the Ministry of Foreign Affairs, and I have been posted. I have been here in Nagoya just for 3 months, so I'm a newcomer. So I would like to congratulate Professor Shibata and PCRC for organizing this workshop. And I wish all participants a happy World Antarctic Day. And I will briefly talk about the legal, administrative, and institutional aspects of Türkiye's case in relation to the Madrid Protocol. Turkish scientists' interest in Antarctic issues dates back to the late 1960s. However, it takes years for the scientific interest to find place at the governmental level. Turkey signed and ratified the Antarctic Treaty in 1996. Since Turkey regards the polar regions as crucial in the efforts to combat climate change, Turkey's interest in Antarctic affairs has increased gradually in parallel with the developments in the international legal framework on climate change. The Polar Research Center of Istanbul Technical University, established in 2015 as the first of its kind, initiated the Antarctic research and studies in Turkey. With the help of this center, Antarctic studies began to be conducted under the auspices of the Turkish presidency. After the completion of the first national Antarctic expedition of the Republic of Turkey in 2017, the National Polar Science Program, covering the years 2018-2022, was approved by the Turkish Ministry of Science and Technology. The aim of the program is to increase Turkish contribution to scientific knowledge on Antarctic regions through expeditions and international cooperation, to establish a permanent national scientific base in the Antarctic region, to become a consultative member of the Antarctic Treaty System. This program worked for Turkey on 3 fronts: increasing in terms of increasing scientific research and studies, improving institutional structure, and boosting legal framework. First of all, Turkey has conducted 7 national Antarctic expeditions since 2017 and completed 121 scientific projects, which resulted in 252 scientific outputs. Turkey has been participating in ATCM and CEP meetings as non-consultative member since 2016. And as for improving institutional structure and coordination, in order to ensure a more concerted effort at national level on Antarctic matters, the Polar Research Institute under the Scientific and Technological Research Council of Türkiye, a related organization of the Turkish Ministry of Science and Technology, was established in 2019. As a result, the said ministry appointed the PRI, Turkish PRI, of TÜBİTAK as the responsible body to conduct the project for establishing a permanent national base in 2020. Therefore, Turkey has managed to institutionalize its Antarctic policies, which resulted in achieving full membership of both the Scientific Committee on Antarctic Research and the Council of the Managers of National Antarctic Programs in 2021. And thirdly, for boosting legal framework, Turkey ratified the Madrid Environmental Protection Protocol and including all of its annexes 1 to 6 on 27 September 2017 and notified the depositor of its ratification in October 2017. The Turkish Ministry of Environment, Urbanization and Climate Change is the focal point in the implementation of this protocol, including Annex 6. In this regard, the Turkish Ministry of Environment and this ministry prepared and adopted a specific regulation for its implementation in domestic law. This regulation named procedures and titled Procedures and Principles Regarding the National Polar Science Expeditions and Activities entered into force on 13 June 2020. So the adoption of this regulation has been a touchstone in terms of establishing organized and regulated domestic procedures in line with the Madrid Protocol with a view to establish a permanent Turkish scientific base on Horseshoe Island. To conclude my remarks, actually the adoption process has been smooth due to various factors. For instance, Türkiye has a relatively recent history in the Antarctic region. Is a newcomer, so that means there is no specific law in Turkish legislation regarding Antarctic. And secondly, right now, there's no, even though we are implementing Madrid Protocol, it is, it's currently implemented in practice for only state actors because conducting an expedition to Antarctic is a costly project. So that means it's undertaken by the government itself. Although the current legislation, the regulation, covers all the parties, also non-state actors too. And thirdly, we have a flexible system because in our system, the position of the status of the international law is higher than the domestic law. This means we don't have to approve a special act to improve a separate act to approve an international convention or an international document. So this means that we complete the approval process, and then the related focal point, a ministry is assigned as a focal point, and that ministry, if they see the need to issue a regulation, they issue a regulation. That regulation is only signed and approved by the minister. This is a flexible system because it's easier. Otherwise, if you want to change the regulation, if it were an act, it should go through the amendments, should go through the parliament in our system. But if it is signed by the approval system is only goes to the minister, so it's easier to make amendments. And we do this, for instance, for, just to give an example, MARPOL Convention, because it's changing during the IMO meetings. And what we do is basically we change the regulations signed by the Minister of Transportation. And these are the good points, but also we don't foresee any future what will happen in practice. How do we, for non-state actors, how we will implement the regulation itself? We don't know, because there is no such example. And this regulation also foresees only administrative penalties, because our Ministry of Environment can only issue administrative penalties. So this is there is no connection to criminal law. But since it says there are only state actors in our criminal law system, still Türkiye has Turkish courts can make judgments on these cases as long as it's a state actor. Thank you very much.
Thank you very much. That's very interesting. Turkey being a non-consultative party, ratifying all the 6 annexes and also implementing it. It's a tremendous work. Thank you. So can I ask from online, Claire Christensen, for her comments on this issue? Could you put the video on, if Claire? Oh, thank you very much. Okay, we can see you. Thank you very much.
Before I start, I wasn't sure if Sarp was going to say something to follow up his colleague's remarks.
Okay, I'm sorry about that. Should I, Sarp? Yes.
Maybe at the end of the session, maybe if there is time, I can say just a little words, because Consul General Damla Gümüşkaya just perfectly summarized all the issues. So I don't want to take too much time off this panel. So thank you.
Thank you. Yes, of course, we'll have the discussions after. Okay, so Claire, please go.
Okay, well, thank you very much. And thank you very much for this workshop, Professor Shibata and the PCRC. I think this is a very timely event to have. And I think I'm not a lawyer, and ASOC doesn't work on the details of implementing legislation a lot, so my comments will be more general, but I hope they'll be useful and interesting to the participants. Along with Annex 6, there are a number of measures adopted by the ATCM in the past that have not been ratified in all the countries and have not yet entered into force. And so I think this is very relevant, given that there are increases in tourist activity, and many ATCPs, or Antarctic Treaty Consultative Parties, have expressed a desire to have a more comprehensive approach from the ATCM to managing tourism, but yet we do not have the Liability Annex entered into force. We do not have Measure 4 from 2004 on tourism and non-governmental activities entered into force yet. And we also don't have Measure 15 from 2009, which is a measure that bans landings from vessels with passengers over 500. So I think that's very important to consider, in thinking how the ATCM will act in the future. How has it been able to implement its own decisions in the past? And I think, with this case, we're almost 2 decades on from Measure 1 and still have not entered into force. And I think that's something that parties should be taking a hard look at in terms of whether they are actually meeting their obligations under the treaty and protocol. Typically what we see from our perspective as an expert organization and not a party is that during discussions about decisions by the ATCM, parties are usually very careful not to agree to anything that they don't think is possible to implement under their domestic law. so we do assume that parties are not agreeing to anything that they cannot get through and cannot implement and ratify at some stage. But it's, like I said, it's been almost 2 decades since Measure 1. And so it's clearly not a simple matter for some countries. But at the same time, a number of diverse parties and with diverse legal systems have managed to implement it. So it clearly is possible. So that kind of begs the question for us from the civil society perspective: is this a matter of just capacity? Are these countries too busy with other things to think about this, or do they simply not want to, and they've put this off because they don't think it's important? And in that respect, I think it's easy for us to say that Antarctica is far away. The level of human activity is fairly low there, so the risks of harm from not having the liability annex entered into force could be low. So we can take our time. But I think the principle from our perspective is really important here, not just for potential accidents in Antarctica in the future, but for the future of the continent and its environmental protection more generally. The protocol is an excellent document in many ways. It's forward-looking. It has all these different annexes that cover, a wide range of things that you need to effectively protect the Antarctic environment, and many of them were, fairly ahead of their time. But these are ultimately not very meaningful if they're not applied in practice, if they're just intentions and, hopes for the future rather than something that is backed up by law. And we've even seen in the Antarctic Treaty System, or at the ATCM a few years ago, there were some incidents where people landed on the continent from a small yacht, and they broke into a historic house and caused some damage. And, during the course of those people being prosecuted, it was discovered by the country prosecuting them, which I believe was France, that they didn't have sufficient domestic law to really deter and prevent and prosecute people who did these kinds of things. So that just goes to show it's always better to be prepared than to after the fact realize that you don't really have a way to address a very serious situation. So I think it's really important for the ATCM as a whole and Antarctic Treaty parties specifically who haven't ratified these measures and haven't ratified the liability annex or approved it. Is the ATCM really able to be effective? Is it able to respond to major issues affecting the Antarctic environment, particularly in an era of rapid climate change? And I think to us, it's very clear that something is going to have to change for the system to remain effective. And another thing that we often hear at Antarctic Treaty meetings is that the Antarctic Treaty System is competent. They have established a good series of international laws for Antarctica, and they don't need interference from any other outside bodies, whether that's the United Nations or anyone else. But if they don't want other countries and the rest of the world to be, scrutinizing them, and they want them to leave them alone to do their work of protecting Antarctica, then they also, to some extent, I think, need to demonstrate that they can do that, and not being able to implement decisions that were taken, decades ago is not a good indication that they are capable of doing that. And the legitimacy of the Antarctic Treaty System has been questioned in the past at the UN. And, I'm not saying that I want that to happen, but I do think that if parties are so just determined to, keep Antarctic affairs within the Antarctic Treaty System, they probably do need to make some additional efforts to get this done. And I think possibly there is an opportunity here for countries that have already completed their domestic legislation to, maybe start kind of, I don't know what a good term for it would be, but maybe like a support group for countries that have not, and try to help them out and try to raise the profile of this, because it is probably an issue with everything that's going on in the world that can easily be given a lower priority. But at the same time, in many cases, it might be simple because it's a little bit less politically controversial or difficult in that sense. So I think maybe there is a way that for other parties to not to interfere in maybe a domestic legislative process per se, but to help and provide support for their fellow treaty parties in the interests of the overall system remaining functional and being able to demonstrate to the world that it does what it says it's going to do. So anyway, those are very general remarks, but thank you for having me, and thank you again for having this workshop.
Thank you, Claire. That was a very important message from the civil society, and following all the intricate negotiations of the ATCM, and we have received your message very clearly. Thank you very much, Claire. And please stay on because we are going to have a discussion. And maybe so we can come back to Saab. If you have any additional comments, I think we will hear it, and then we will open the floor. Saab?
Thank you, Professor Shibata. My name is Sarp Ergüven. I'm an assistant professor at Ankara University Faculty of Law. My field is public international law, and right now I'm a visiting scholar at Tulane University in New Orleans, and it's like late midnight right now, so apologies for I'm a little bit exhausted. And I also want to thank you, KOPRI University, PCRC, and also KOPRI for organizing this important symposium. And also, I would like to especially thank Professor Shibata, because Professor Shibata always creates this perfect environments for scholars to from different countries to interact with each other and also learn from each other. And also I especially want to thank Professor Shibata for his this inclusive approach. Like I said, Consulate General Damla Günüşkaya perfectly summarized the case of Türkiye. Maybe I don't want to take too much time of this panel, but maybe I can just highlight some issues regarding Damla Günüşkaya's presentation. The main system of Turkish domestic law regarding the relation between international law and domestic law of Turkey is a mixture of monist and dualist approaches. The main rule regarding this issue is Article 90, the Constitution of Turkey, Article 90, that if Turkey signs a treaty, National Grand Assembly of Turkey must adopt a ratification law in order to this treaty or any other international document to be binding for Turkey. So in case of Antarctic Treaty and Environment Protocol, National Grand Assembly of Turkey adopted these ratifications laws, and also like Ms. Gümüşkaya highlighted in her presentation, regarding Environment Protocol and also Annex 6, there are two regulations under Turkish domestic law. The first one is the regulation of the implementation of the Environment Protocol of Antarctic Treaty, which dated in 2020, and also there is another legislation regarding Polar Research Institute of Turkey, titled Procedures and Principles on Turkish Polar Science Expeditions and Activities. Both these legislations and regulations has articles regarding to Annex 6, and like Ms. Gümüşkaya highlighted in her presentation, right now Turkey has a temporary research base in Horseshoe Island. But in upcoming years, Turkey is planning to establish an Antarctic research station, a permanent research station in the same area, and also this regarding this station, the comprehensive environmental evaluation plan adopted in CEP and also in ATCM. So right now, Turkey conducted until now 7 Turkish Antarctic expeditions, and during these expeditions, chartered ships used for these expeditions. So, like Ms. Gümüşkaya highlighted in her presentation, there isn't any governmental ship flagged using a Turkish flag. But in upcoming years, especially following the establishment of the permanent Turkish research base, a more comprehensive, maybe an polar law like Korea and also India, a more comprehensive law and act must be implemented under Turkish law regarding the enhancement of scientific activities of Turkey following the establishment of this permanent research base. So this is my personal observation. I'm also a legal advisor of the Turkish delegation to ATCM and also CEP meetings, but this is my personal observation and doesn't represent the position of government of Türkiye. And thank you for your patience. Thank you.
Thank you, Sarp. And despite the very difficult time zones you are in, thank you very much, Sarp. Thank you. All right, so we have a lot of time for discussions, and of course, we are the lawyers. However, and of course, we try to discuss the lawyer's role in consensus building. But this Annex 6 issues deeply involves the practical activities in Antarctica. And many of us, including Japan and China and Korea, India, the main activities in Antarctic is scientific expeditions. So we really need to listen to those people who have the knowledge of the expeditions and whether what we as lawyers consider as an appropriate implementation of Annex 6 is also appropriate for the logistical and also science organization. So maybe as a co-chair, can I ask Chul to maybe have comments, maybe also maybe for questions for the lawyers? Thank you.
I have 3 observations to make. ATCM every year, there are some awkward minutes when the consultative parties are requested to report on the progress update of Annex 6. Almost just about everyone is saying, we are working on it. And then personally, I think when I think of Annex 6, yes, we need to do it someday. The biggest benefit of this workshop for me, and the one point that I'm particularly thankful to Akiho, today I'm leaving with a thinking that this is doable. We have to do it. And it may be not easy, but it may not be terribly difficult. So first point, it's doable. Secondly, we may say, who cares about this Annex 6? It's in Antarctic, very long, far away place. But for me, Antarctic is where future comes first. Whether this is climate change, whether this is technological development, Antarctic is where future comes first or future comes early. What we do in the Antarctic will impact us, and what we do in other international space or in the future. So it's a kind of testbed and touchstone. So this gives meaning how we tackle with Annex 6. Thirdly, I have learned a lot, the Turkish case, Finnish case, German case. So next time, our seminar or workshop should be on knowledge exchange, how they have overcome the difficulties in addressing this Annex 6 issue. In fact, every country has different systems and different experience, different know-how. But if you just everything on one table, there may be some lessons. Thank you.
All right. Thank you, Chul, for having us reminded of next steps. I think this is only the start of a process, and I hope this will be a good, constructive start point. But yes, if any of the speakers have any comments or maybe some questions for particular presentations, I think we can take them now. Anybody from the speakers? Right. Okay. All right. Of course, Claire from the online, she mentioned about this with regard to the possible future next steps about this supporting group of those consultative parties who have already approved it, and so that we can learn. And Chul also mentioned about this knowledge sharing. It's already going on. As many of you know, Australia is leading an official intersessional contact group on the Annex 6, and our hope, my hope at least, the personal hope, is that this academic gathering can have a constructive contribution to such an official route. And that's why that we would like to make this video recording publicly open, so that any interested stakeholders, including government officials, may look at them. So that's the very reason that we would like to support the official intersessional contact group run by the ATCM, led by Australia. Yes, with this my timing, any questions from the speakers now, or maybe online, or maybe not? Okay. So maybe can I ask Li Chen and Yitong Chen? You have also expressed the two options for China for the future. One, according to Yitong, is the easier, more appropriate way that you go for the law and then having the regulations. And also Professor Li Chen also mentioned about this approach as the long term, so it might take more time. Maybe could you elaborate how China, if you go through this more appropriate way, having the law first and then the regulations in order to implement Annex 6, what kind of a time span usually, if we consider such a route of having, the law at the legislation level and to have the regulation afterwards? So do we get some kind of indications, that kind of time span?
Okay, thank you for your question, Professor Shibata. So I think I could split your question into two parts. So first part is when I propose China should first enact the Antarctic law and then actually not then the regulation. So what my exact meaning that is, China should enact the comprehensive Antarctic law as soon as possible and to incorporate the content of Annex 6 in this comprehensive law. If in this process, when the legislators feel it is difficulty or it is not enough to implement or to incorporate the specific details of the fund, because I think it is very complex, because fund is a cross-cutting issue, and also the penalties, right, relating to the criminal and also the civil law, right? So the fund and the penalty is very complex and cross-cutting. So if this kind of difficulty arise, so maybe the future regulations is a supplement part for supporting this comprehensive law. But the better way that is to enact a very comprehensive, detailed, and complete Antarctic law, instead of future supplement regulation. This is the first part for your question. And the second for the time span for yearly, right? So you ask yearly of how long, right, between the comprehensive law to the regulation. I think it is totally depends to the different topic and situation. So that is the reason why I present my PowerPoint in this way. So I give the example of the legislative history of the CBD and supporting domestic and that's the reason I give the example, the deep seabed mining law and regulations. So you could see from the example, it is totally different situation, right, relating to the different topics. So the CBD, it looks like a very long time frame, right? So China ratify the convention and agreements as soon as possible. Right. So, and following many times for the modification of domestic laws and different topics relating to the protection of the biodiversity. Right. For the UNFCCC, okay, it is a very comprehensive issue for combat climate change, and you know the history of the of China participated in the climate governance from a very quiet participant to. Right now, you can see active participant in the climate governance. So it also demonstrated and showed in the legislative history domestically. So that's the reason I give you. So the exact question to answer, okay, the timetable between the law to regulation, it is totally depends to the specific nature of Antarctic. So that's why I give the example of international seabed area. I think maybe this is a topic mostly related together. So maybe it only my personal guess, when China issued the Antarctic comprehensive law, maybe it is very fast on the consequence, the ratification for the approvement of the Antarctic 6 and following maybe supplement regulation will be in a very quick way, very quick step. But the law should be the must and the prerequisite, and only my personal opinion and my suggestions for China active participate and contribute for the Antarctic trade system. That's my answer. Thank you.
Okay. So after listening all the presenters, they introduced their respective domestic laws and the process to implementing Annex 6. I found that Japan maybe will be the number one, since you only meet some technical legal barriers. So from my personal opinion, it's much more easier maybe to overcome the difficulties, the technical one, difficulties to implement Annex 6. And then the Korea, I think Korea also you have two leading laws. Is one, it's out of my imagination, expectation. You even have the, we call it it's a promotion, right? Polar activity promotion law. So combine both Arctic and Antarctic. So it's also at a very high level. The laws is only is also at the very high level. I think it's also much more easier for you maybe to implement Annex 6 very soon. And the China's situation actually is a little bit complicated. As I mentioned that a comprehensive Antarctic law has been planned actually 6 years ago. 6 years ago. I can't imagine that. Just like a news, just before it's 2017, right? But now, though it is still under process, but we can really hear the further promotion, the news on this law. So I think that Yitong also mentioned that the deep sea mining law is very quick, right? It's very quick. I think the academia, the commentators, and the professors, they play a very important role and functions to promote such law to be discussed and in the National People's Congress. And I think, but in China, so far in China, only I just discussed with Yitong. So not so many scholars, international law professors, they focus on the Antarctic and Arctic legal issues. So implementing Antarctic law is seldom discussed so far in China. So I think the academia and all the professors in international law, they should play a more important and positive role to write articles, to push the government and the National People's Congress to consider to implement Annex 6 as soon as possible. So this is our role to do that. But we cannot control the governments and the Congress, their conduction to adopt the law. In how long I don't know how long it will take to have the comprehensive Antarctic laws. Okay, that's my question. Yes.
Yes. Well, thank you for that encouragement, and I think it's worth that we had this workshop, and we'll continue to have such seminars as Chul has said. Okay, Kanagasan. So basically, India already has the law and probably the implementation part within it. So I think you are fine. And having heard from the others, do you have any comments on the Indian situation or generally on the Annex 6?
Generally on the Annex 6, I would agree with the Chinese professors. Like, it needs the academicians to push it further ahead, and I mean, with the government, and we will have to wait and see how it takes shape and how long does it take. Already it has been so many years to implement. I mean, the 13 years ahead of Measure 1, and now again so many years. So we need to push from our side, present the research papers, and look for governments to see where it all takes forward and shape. Yeah. Thank you.
IMURA-san, having no, okay, thank you very much. Thank you. And of course, Wonsang from online, or even Chul, do you have any additional comments for the more specific future ahead for us?
From government officer who needs to practice, in our case, is very much concerned, okay, is this doable? Is this domestically implementable? What are the technical difficulties? Then they will be very curious about the financial security and insurance stuff. For example, the state operators may respond first by contract or something like that. And then would it require having some sort of fund reserve in place always, just in case something happens? So for that kind of aspects, I have many questions or to ask, but I'm happy to do it. Yeah.
I think the Indian law does have an interesting provision. Maybe can you explain that the 10% reserve that the law actually provides for the cases where the operator might cause some environmental emergencies?
Yeah, it's not part of the act, but it's part of the rules that in the Antarctic Fund, whenever there is an expedition or whenever there's a vessel or an aircraft that goes in to do activities there. So there is a particular security amount that has to be deposited towards the Antarctic Fund. So in case of any environmental emergencies, then this could be utilized for that particular purpose. So I don't know how exactly it works, but this is a provision that I could read in the rules of the committee is responsible. The CAGP is responsible to decide how to utilize the Antarctic Fund. So this is some interesting provision that I found in the Indian Act. Yeah.
So I think we have been very creative and innovative of trying to implement those provisions of the Annex 6. which are more suitable to specific countries. And I think we have different, activities in Antarctica. Some countries would be more interested in the regulation of non-governmental activities, especially the tourism activities, whereas other countries would be most likely, looking at the scientific governmental activities. And I'm sure because of those differences, we would probably think of different ways of implementing it. And again, I have been emphasizing that there is intentionally a maximum flexibility built into the Annex 6, so that each constitutive parties consider those innovative and creative ways to implement it. And of course, there should be some kind of a harmonization when it comes to the actually implementation of it, and some difference of views might occur after practicing the Annex 6, of course. But then we can discuss those issues in the ATCM and consider how we can somehow harmonize it afterwards. But we don't need to, according to my personal view, is that we don't need to consider those harmonization at this moment. We don't need to align with other countries' implementation measures. We really can consider ourselves and how we can do it. So that's my view. And another issue that I was encouraged to hear, especially from the German and also Finnish cases, is that direct application or direct implementation, especially with regard to state operators, is a recurring ways of implementing Annex 6. And I think that would be probably an easier way of considering implementing Annex 6 with regard to the state operators. And then the issue is the other non-governmental organizations, non-governmental activities. And for that, going through the Finnish and also German, and my personal, of course, view is that administrative implementation or administrative ways of approach to the implementing those allocation of responsibilities and also getting the money out of the operators. There are already German cases which implemented. And I also consider for Japan that would be most likely the case. It would be easier case, I think, by implementing Annex 6 through the existing Japanese Antarctic Environment Protection Law. So it's very encouraging that there are already cases where they try to implement the liability of non-governmental operators through administrative ways of implementing them. So that was a learning process also for me and also for many others. So those are my like a kind of a summary. And with regard to the future ahead, I think we would have this kind of academic meetings and also maybe provide some concrete summaries of it, and maybe some suggestions that can be put up on the website so that anybody can see it. Of course, the video recordings are already up there, but maybe we can come up with some kind of a summary so that it's much easier to just read in 1 or 2 pages. So that if that's acceptable to the other speakers, of course we'll come to you and have agreed papers coming out of this meeting, so that it will be easier to refer to the conclusions of this seminar. Thank you. All right. Let me see. So there are no questions from online, and of course the time is already up. Any final views from the speakers? Okay, so Sarah, and of course we'll come back to Damla. Thank you, Sarah. Yes, thank you.
All right. Okay. It was a pleasure to be here, and thanks to Professor Shibata to inviting me, even though I'm operating in another field of humanities. But like talking from Italian perspective, first of all, it was really interesting to see and to listen all these really insightful presentations, especially to not investigate, but explore the language and dynamics between the countries who are still working on the implementation Annex 6. From Italy perspective, I'm on a safe side because we implemented. And I mean, if I can just give my 5 cents of Italy at this point, some quite valuable information, since it was Italy was mentioned at the beginning of this workshop. So Italy became one of the 29 consultative members in 1987, which have the right to vote, decision-making, and control power on compliance with the treaty. And since 1987, Italy has also been one of the 44 members of a scientific committee for Antarctic research, the SCORE. And since 1988, it has been part of the group of 32 nations considered full members. And according to Italian legislations, I see some similarities between Turkish domestic legislations, especially on a constitutional side, because also when we implement international legislations, of course we sign, we ratify, but we need an act of adaptations to apply tailored strategies of international acts to our domestic legislations. And we have different mechanisms to guarantee the fairness of this application, but generally international law has legislative supremacy over the domestic legislations. But we have different offices who are working on the Antarctic treaties and ministries. I might not going too deep now because I joined and step into the discussion so late. But I mean, it's not worthy to mention the Ministry of University and Research, who is responsible for the National Antarctic Research Program, and the Ministry of Foreign Affairs, who is responsible for international political aspects relating to Antarctica within the framework of Antarctic Treaty System. And Italy has ratified even valuable others convention. And about scientific research, I made some research before participating to this workshop. Italy has two scientific bases. One is joined with France, Concordia, and one is inside the Italian, Zucchelli, in the Sea Dome region of Antarctica. And also has, Italy, the government has granted 12 million of euro to a new icebreaker, going for conducting research over there. And also Italy has a different program about scientific research programs. Might also list briefly EPICA, which is a project to study the ice at Dome Sea, and the Cape Roberts and Andrew program both aim at understanding the geological evolution of cyanosis through sedimentary link, and Boomerang astrophysics experiment, and also Italy has contributed to study the ozone hole. And it has also different agreements with several countries, which are what I found, bilateral agreement with Argentina, but even with Korea. It is a new agreement with Korea that was signed in December 2018 with a specific memorandum of understanding, and it was signed between the ministers and KOPRI. We also have a bilateral agreement with France, of course, because we share one scientific base. And also, we were working to conclude an agreement with China. We might need to double check. Maybe we can discuss together, because I didn't find any feedback or any others final outcomes from them. And regarding to the ATCM, so in 2025, Italy will organize the 47 ATCM, so the Antarctic Treaty Consultative Meetings, the annual conference of the 56 signatory countries of the Antarctic Treaty. And the Ministry of Foreign Affairs and International Cooperation, through the General Directorate for Globalizations and Global Issues, conducted a preliminary market consultations in order to acquire information on the existing offer for the services necessary for the holding this sort of conference in Italy. So the call ended this October. So, I mean, I would like maybe in the future to share new information about this, but I might say as a really final words that this workshop was really interesting. Actually, I would like to write something on this because it narrowed a lot the topic, and thanks for all the presentations because it helped me to find the right methodologies to research better and more on this field.
Thank you. Of course, we are all looking forward to going to Italy, and we are wondering which city that we can go. So I'm sure that will be announced very soon. Thank you. So maybe Damla, would you like to? Yes.
I don't want to take much of your
That's
time,
okay, please.
But I would like to point out one thing. When we are, of course, we aim to we want the Madrid Protocol, the 6th annex, to enter into force with the approval, hopefully approval of the 4 consultative parties. But this should be the midterm goal. The long-term goal should be including all parties because Antarctic region is the common heritage of mankind. So it should be what we should do is we should, come together and discuss the best practices because we learn from each other, and we should do it earlier than the entry into force. So we should have also a long-term goal, and this is coming from a practitioner because I know the value of academicians can pressure the governments, but if we do not hold some consultations at at least junior official level, inspired by or supported by academicians, we will not get one step more. What we should do is we should put this long-term agenda, including the midterm agenda, all together in front of the officials' table so that they have an idea what to expect in the future instead of doing it at the last minute. So they know what's coming. That's although I'm on the government side, I can say that this is the case because sometimes it is difficult to convince the politicians to take steps. What we should do is to discuss more so that they have an idea about it. Thank you very much.
Thank you for that very good advice for us. Thank you. Chul, yes. Maybe we can close, yes. And any final words from you? No? Okay.
We'll just continue tomorrow.
Okay, thank you very much. Yes. Okay, so thank you very much for your participation, and this concludes the international workshop on the Antarctic, future of the Antarctic governance. Thank you very much.